Need to change.
We're not
It
changing
said
any.
True to 1 and 3. Do we need to do anything else?
No,
Or
you're
just
not.
Sentence, but sentence in accordance with the agreement.
Yes,
Okay.
sir.
3 defendants, 3 very different outcomes. One accepts a prison deal, one rolls the dice on trial, and another admits violating probation. Which decision pays off and which one comes with a costly consequence to review?
Good morning, sir. Are you Justin Jacoby Joseph?
Yes, ma'am.
And Mr. Joseph was previously in court. We're hearing cause numbers 20-35818 and 20-35476. And Mr. Joseph is on probation in those cases for possession of a controlled substance, a second-degree felony, and evading detention with a motor vehicle, a third-degree felony. Entered pleas of true in each of those cases to counts 1 and 3. In those motions to revoke, I've received the updated report as well as some letters of support. Has you both had an opportunity to review all of that?
Yes, sir. I'm here.
Yeah.
Any additions or corrections to that report?
Notice.
No, Your Honor.
It's my understanding at that time, there was no agreement, but at this time there has been an agreement. Is that correct?
That's correct.
And so, Mr. Joseph, I have here on the tablet some documents in each of your cases that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you understand if I follow that agreement that you've made in these cases, that if I follow it, you'll be waiving or giving up any right to appeal?
Yep.
State tenders number 1 in each of those cases?
Location.
It's admitted in each case. Anything different with regard to competency or?
No.
All right. So Mr. Joseph, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true and find sufficient evidence to find you guilty. And cause number 20-35476 finds you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 20-35818, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed. So you did waive your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lewis. All right. Good luck to you, sir. Let's see. John Lamel.
John.
Good morning, sir. You're Mark Garcia. And Mr. Garcia, we've gone through all this before, but I'm going to go through it again today to make sure we're all on the same page. In cause number 25, DCCR 0120, you're charged with the state jail felony offense of theft of material, copper, and that's from April 7th of 2024. Your indictment alleges you were previously convicted of the state jail felony offense of theft and theft of material on February 22nd of 2022. And then after those were final, it shows that you were convicted of possession of a controlled substance, a state jail felony, and then fraudulent use of possession of identifying information, a state jail felony, September 19th of 2023. What that means is that if you go to trial and you're found guilty and those prior convictions are true, you would be enhanced to a 3rd degree for punishment, which means the possible punishment would be between 2 and up to 10 years in prison. Do you understand?
Yes, ma'am.
And the state has made an offer if you wanted to enter a plea of guilty at this point to for a 5-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are, what your options are. Do you understand all of that? And do you want to reject that and have your case set for trial? All right, I'll get that done. And so I do want to make sure, Mr. Garcia, that you understand once your case is on the trial docket, I don't typically accept plea agreements. unless there's new information or evidence that the parties did not know about. So if you change your mind later and want to enter a plea.
Here's the turning point. The judge is making it crystal clear that rejecting today's offer could mean facing a much harsher sentence later. It's a gamble many defendants take, but not all of them win. Interview 2-3 cases, 3 choices, and 3 very different futures from negotiated prison.
If guilty, it would be to something different. It would be either open to the court or to something different than 5 years. You understand? Okay. I want to make sure everybody understands that once it's on the trial docket, it's not just to buy some time so you get a better deal, because that's not how it works. Mr. Garcia, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Lewis, you'll remain on the case and begin preparation for trial. We'll get it set on the next available trial docket.
May I just, excuse me, put on the record that we will intend to call Thomas Valentino, the co-defendant, who's already taken responsibility for this case and pled TDC time. I do know his whereabouts up in Round Rock, and I believe Mr. Garcia is guilty as a party, and I will be calling him as a witness.
All right, thank you. If that changes anything, let me know as quickly as you can. All right, you can go back with the bailiff. Good morning, sir. You're John Lamel.
Yes, ma'am,
And Mr. Lewis, will your client waive the formal reading of the motion?
he does.
Mr. Lamel, in cause number 21-38857, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 1st of 2023 for the offense of theft of property, a state jail felony, and that was a 3-year deferred probation that's been extended. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the offense of unlawful carrying a weapon January 2nd of 2026 in Jefferson County. And is that true or not true?
It's true.
Count 2 alleges that you committed the offense of fleeing a police officer January 2nd of 2026. And is that true or not true?
That's true.
Your Honor, the state would abandon counts 3 and 4. Oh, and 5. 3, 4, and 5.
Count 6, thank you, Mr. Coleman. Count 6 alleges that you failed to complete the JCDI program as ordered. Is that true or not true? Did you complete the program?
No, ma'am, I was almost ready to go.
Yeah, but you didn't complete it.
Yes, ma'am.
So that's true. Count 6. And then, all right. So did you enter your pleas of true to counts 1, 2, and 6 freely and voluntarily?
Yes, ma'am,
And did you plead true to those counts because they're actually true?
actually true.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Ma'am,
Do you fully understand them?
yes, ma'am,
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Lamel is not competent?
No.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft. Sentence you in accordance with your agreement to a term of 180 days in the state jail prison. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Risky trial strategy and a probation revocation. This courtroom session is a reminder that every decision in court carries real consequences. Which outcome surprised you the most? Let us know in the comments.